Thank you very much, and good afternoon. Thank you very much for the invitation to come here today. I'm very pleased to be able to be here, not least of which because human trafficking and modern-day slavery is not something we can deal with in isolation. We have to deal with it together. It doesn't just affect the UK, it happens in all of our countries, be we source, transit or final destinations. So it is really encouraging to see so many people here who can make such a difference. So thank you for allowing me to be here and to talk. Human trafficking, of course, can have a devastating effect on its victims. We know that, and we've heard already today many examples of that. But we need to make sure we take a humanitarian approach right from the outset in order to protect the victims and to help them recover from their ordeal, and also to encourage them to give us the best evidence possible and to cooperate with the criminal justice system and so support successful prosecutions which will hopefully deter future traffickers. When it comes to human trafficking in England and Wales, we work in close partnership with organisations across the criminal justice system, both at home and abroad, to bring successful prosecutions. I work very closely with the heads of prosecution services in Scotland and Northern Ireland to ensure that we provide a robust and consistent approach to improve prosecutions across the United Kingdom. The Lord Advocate of Scotland and I have hosted 2 summits, one in Edinburgh and one in London, where we invited parliamentarians, prosecutors with experience of human trafficking, law enforcement and third sector organisations to contribute to our discussions so that we could learn how we might best tackle this trend in trafficking together. For us, one of our main issues is the identification of victims, and this continues to be a real challenge, and we've heard about that already this morning. In 2013, there were just over 1,700 victims referred through our national referral mechanism. This rose to over 3,000 in 2015, but it is likely that many more victims are not identified. We know that victims will usually not self-identify either through fear or coercion or because of shame for many different reasons, and therefore it requires a more proactive approach from both investigators and prosecutors in order to recognise them. Increasingly, we are seeing victims who are forced into criminality, and so law enforcement and prosecutors must be alert to this and must refer possible victims so that we do not further victimise them and prosecute the wrong people. The identification of victims referred through our national referral mechanism recently has also revealed changing trends in England and Wales. Previously, more victims were trafficked into sexual exploitation than labour exploitation, and victims were significantly more likely to be female than male. During 2015, we saw a shift to more adult victims of labour exploitation rather than sexual exploitation. And we're also seeing a rise in the number of male victims. During 2014, 39% of victims were male. In 2015, the proportion had risen to 46%. So it's important that prosecutors understand the changing trends and understand how they need to be aware of what a victim might look like if there is such a thing. So returning to how we make sure that prosecutors do this, we have various documentation for them. They make decisions in accordance with the Code for Crown Prosecutors, but we have specific guidance in relation to human trafficking and modern-day slavery. This is updated on a regular basis to reflect legislative or case law changes, sentencing guidelines and policy changes. And it's published on the CPS website, so it is accessible to others, not just to prosecutors. We draw on good practice arising from our experience of dealing with cases of trafficking and slavery, especially those where complex or novel issues arise. So we make sure that prosecutors are aware of this and understand how they might best support victims and how they might build strong cases to take before the courts. Cases of human trafficking and slavery are prepared and prosecuted by specialist prosecutors who are experienced and who have been trained in dealing with these cases. Training has been focused on prosecutors who deal with these to make sure they understand issues such as what a victim might need to help support them through a prosecution, how a victim may present, and how not to judge a victim, particularly around their credibility. As Kevin has already said, many victims will be victims who go back to those who have trafficked them or go back to those who have forced them into labour. And prosecutors are reminded not to judge victims by their credibility, but to look at the allegation as a whole and to support victims through the process. So how do we do that? Well, we work very closely with our police colleagues and make sure that we are working with them at a very early stage to identify evidence that will help and support prosecutions. Recently, we have developed a joint checklist of vital evidence to support trafficking prosecutions, and in particular to progress victimless prosecutions. We are very keen to look for ways in which we might help the police to investigate and to get the evidence to support charges. Sometimes this will involve seeking evidence from overseas, sometimes evidence from documents, mobile phones and IT equipment which has been seized from traffickers, as well as financial and banking evidence. If we can build cases where we do not need to rely on the victims, this will assist them in their recovery and their burden, but we can't always do that. We also make sure that we look at human trafficking and slavery offences for the purposes of confiscation. This means that under the proceeds of crime legislation in the UK, this means a court can assume that all the assets a defendant has acquired over the last 6 years are from crime, and it is for the defendant to prove otherwise. This enables us to seek an order to confiscate the defendant's assets. This is important, but not something that we have traditionally done very well at in human trafficking and slavery cases. Why is it important? It's important to deprive traffickers of the money that they have raised through the trafficking and forced slavery. That's why they do this. They see people as a commodity in the same way as they might do drugs or guns or any other illegal commodity which they traffic. So it takes away their reason for doing it. It also means that we can prevent the money going back into more trafficking, and the money can be used to help victims through compensation for them. So we're very keen to make sure that we up our game in relation to proceeds of crime and have financial investigations running alongside investigations to produce evidence of modern-day slavery or human trafficking. Of course, we can't do this alone. International cooperation is very important, whether through the use of mutual legal assistance, police-to-police inquiries, or joint investigation teams. And this way, we can provide evidence to the courts of victim recruitment, travel arrangements, and also previous records. Joint investigation teams, we have found, have been the most effective way of being able to investigate and prosecute organised networks involved in trafficking across EU member states, but can also be set up between countries outside of the European Union, provided the legal basis exists. We also work with the police very closely to make sure that we discuss victim strategies at the earliest opportunity, which will help to assist victims in giving their evidence if they have to do so. So we make sure that we identify with them how they would like to give their evidence at trial, and this is especially important in cases where victims are particularly vulnerable, such as children, those with physical disabilities or learning difficulties, where we may have to think of more innovative ways to help them give their evidence in court. So for example, through the use of intermediaries which can help effectively translate questions for them and make sure that they understand what they are being asked so that they can give the best evidence possible. It is possible for us to prosecute a case of human trafficking without the victim, where the police have conducted a proactive investigation, but of course it is still more usual to rely on the victim's testimony. So in order to reduce the burden on the victim, it is important that we provide evidence that will prove the case so that we minimise their involvement in the process as much as we possibly can. But we know that victims and witnesses regularly take significant risks when giving evidence against their traffickers. They often fear the consequences of giving evidence, either for themselves or for their families, and are reluctant to do so. Therefore, under our legislation, we consider them all to be vulnerable and intimidated victims, and as such are entitled to enhanced rights and services to assist them. So, for example, when giving their evidence to the police, victims can give their statement through a video recorded interview taken by trained interviewing officers. They will be assisted by an interpreter, and in some instances, as I said, an intermediary will be used to help facilitate that communication. That video recorded interview will be used in court, so they do not have to repeat that again in a courtroom environment. Where an investigation has started, but victims or potential victims may require ongoing protection from harm whilst police inquiries are continuing, we have now started to use the new trafficking risk orders, which Kevin has just referred to. These may be applied for to restrict the activities or the behaviour of the suspects. And these orders can prohibit the suspect from doing anything described in the order for at least 2 years. Breach of that order is punishable for up to 5 years imprisonment. So we have worked closely with law enforcement in obtaining a number of these orders since their introduction in July of last year. So, for example, earlier this year, we worked to obtain risk orders against 2 Vietnamese suspects previously known to the authorities in the UK and France. These suspects were being investigated for trafficking other Vietnamese people into the UK. Whilst the investigation was at an early stage and the suspects were still on bail, there was sufficient information and intelligence that they would continue their activities in order for us to support an application to prevent them travelling. The order was granted, which prevented them from travelling, arranging travel or accommodation for others, and there were also other prohibitions imposed which were relevant to their activities. So in that dangerous period before we were able to bring proceedings against them, we were able to ensure that their activities were prohibited and restricted. Victims of trafficking who give evidence in court are also eligible for special measures, which include a range of provisions to assist the victim in giving their best evidence at court. The police and the prosecutors will discuss with victims what measures will best assist them and what will make it easier for them to give their evidence in court. In addition to special measures, the prosecutor can make an application to the court for further orders for anonymity, reporting restrictions, or for the victim to give evidence through a live TV link when they have either chosen to return home to their own country or where they do not want to physically come into the courtroom themselves. Judge Prince will cover more of this in detail when he talks about the trial process. In some cases, it's also necessary to protect victims of human trafficking or their families in their home country from intimidation, threats and retaliation during investigations or court proceedings or indeed afterwards. In these circumstances, we will work with law enforcement in other countries to provide protection. And with the prosecutors and the law enforcement, we will consider criminal charges against those who have been issuing threats. Likewise, if we are successful in obtaining prosecutions and convictions, we will also work with law enforcement to look at having a prevention order imposed post-conviction. These prevention orders will again impose restrictions on the liberty of those convicted, so will impose travel bans, will impose they can't provide accommodation for other people, they can't arrange jobs for other people, they can't do other things which may facilitate them continuing to traffic. These prevention orders have only been in force since last year, and already we have obtained 17 of those with some very innovative conditions, including conditions which apply abroad. Finally, one of the things that we do need to look at in relation to victims is identifying, as I said at the beginning, that they are victims. That is important not just so that we don't victimise them again, but also so that we can protect them and make sure that we are prosecuting those who are responsible for trafficking and modern-day slavery. It was a welcome addition that in our new legislation there's a statutory defence for victims of trafficking who are forced into committing criminal offences as a consequence of their trafficking situation. That should protect victims from criminalisation and repeated victimisation. In cases where there is evidence or information that a suspect may be the victim of trafficking and a defence could apply under the Act, a prosecutor will of course request inquiries are made and make an assessment on whether or not to continue to proceed with the prosecution. That should happen whether or not we had the statutory defence, and I would hope that prosecutors everywhere are looking at that. I hope this provides you with a useful summary of some of the steps that we have taken in England and Wales. I'm not sure if it is good news, but the number of prosecutions that we have been taking across England and Wales has increased substantially. We have seen prosecutions go up so that we are now sort of in the last year, our last final year of figures have seen prosecutions go up to over 300 prosecutions. I'm not sure whether that's good news. I think in some ways that's bad that we have not prevented it, but at least we can see that we are bringing perpetrators of this crime to justice. I look forward to hearing from the rest of the speakers at the conference, and thank you very much for your time. Thank you.
Thank you.